Well, thanks everybody for your time as usual. We'll we'll save the big topic for after our work group reports, but that'll be Stephen giving us the latest on the draft rules. But we'll go ahead and get the subgroup reports out of the way and hear from everybody who's met since the last meeting. And I'll start with the consumer outreach group. We've been working on the consumer information disclosure form, the form that would be required at the time of signing, and also the consumer brochure, which is a more kind of informal informational piece. Got a lot of great additions during the last meeting and after the last meeting. I'm still kind of working through some of those additions and some of the stuff that folks have sent to me. So I think at this point on both those documents, we're going to try to we'll convene that group again in about probably 2 weeks or so. Yeah, close to final. I don't want to say final because we don't have a pressing deadline, but we'll get the next iteration going, and then I'd like to get that in front of everybody at the next the February work group meeting of the larger work group, which will be about a month from now. So that'll give us some time to really kind of fine tune it some more. There were a lot of really good suggestions. Now we get kind of look at how much can we fit. We don't want to overwhelm folks with too much information, so we need to, I think, kind of look at paring it down to, what's essential and what could be shared elsewhere possibly. So that's about all I have on the consumer outreach side. Those are really our two main goals. We did some more updating to the website to reflect that we are now including power purchase agreements under the definition of lease. So we made some tweaks to the content on the website. And there's a few other things, but those are kind of for other topics. So sticking on the consumer outreach side, that's about all I have on that side. If anybody else from that group wants to jump in, feel free. Otherwise, I'll hand it off to Mary for registration group.
Good morning, everyone. Nice to see you all. The registration work group met on January 14th, and the subgroup reviewed some updated draft rules regarding the registration of salespersons and for the retailers. We also heard a presentation from a company called Recheck. Some of you may be familiar with Recheck. They're the industry registry for solar and home improvement professionals. And so we had Tim Treffren and Jake Ramey. I'm not sure if I'm pronouncing this correctly, but they provided a presentation regarding what their services, their registry that they offer, and how they could possibly partner or assist TDLR with the registration process. And we can probably go into that a little bit later in this discussion. And then we also received updates from Stephen Leary regarding a meeting that Jeff and Stephen had with Texas Department of Insurance regarding insurance policies and coverages. And so they provided an update regarding that so we could finalize insurance requirements. And that's about, I believe that's all we had in our discussion. If anybody else wants to jump in, if I left anything out.
That discussion with Recheck did it raised an idea, and this is just something. This is just like a trial balloon. I'll float out there. We have in one of our programs. I think we may have this in other programs, but the example all site is in our air conditioning program. We have air conditioning technicians, right, or licensees. And there are two types of registrations for them. They're both similar, the same scope, same responsibility, but one is called a registered technician. The other one is called a certified technician. And again, same license, same responsibility, same scope. But a certified technician gets to call themselves a certified technician, and that's somebody who they can sort of advertise themselves to the public as, I have a professional certification that certification has been approved by TDLR. I have a X number of hours of experience, training, that kind of thing, education and background. So it's kind of creating like it's completely voluntary. There's no requirement for anybody to get it, but if you want to get it, you can get it. And that just, it gives the public, I think, a little bit of extra comfort knowing, okay, that person has been, has had some training, has had some additional background check, has an additional level of scrutiny to their work, other than just getting the state license, state registration. So I think if something like recheck were to be, in this space, that could be a way to go. It could be anybody, it could be recheck, it could be, any organization like that issues a professional certification. We could offer that pathway, I think. And Stephen, tell me if I'm wrong. And I think we have leeway in terms of determining what the license requirements are to say, okay, we could have, a salesperson license, but we could have a certified salesperson or a registered salesperson. Take your pick. So anyway, that's what kind of came to mind after that discussion. They had some sort of bigger ideas about partnering with us and getting that would be getting into contracts and all that. We don't. Number one, we don't have any funding to do that. Number two, that's just really not in our scope at this time, or in the foreseeable future. So, but in terms of a voluntary certification, some sort of professional certification, that's very common with a lot of our programs. Professional, we recognize, we have a whole division of education and examination team who they look at professional certifications to determine if they're, valid and recognizable. So that's a pathway. So I'll throw it out there if anybody wants to, yay or nay, or yeah, Pete.
I just want to say, if you go get your, I'm going to have a hard time pulling up the word now. If you're a solar, you go get your training to be a whatever, NABCEP, NABCEP certified.
Yeah.
In NABCEP certification, there's a process where you go do sales first to practice, and then you get the certification.
Yeah.
So if we did something like what you were talking about, we could even include that.
Right,
So,
they could become a registered salesperson, right, which has no requirements. Basically, this background check and that's it. And then they could go out and get their certification. And once they completed that, then they could say, okay, now I'm a certified salesperson. And that's, again, that's very common in our licensing schemes. It's very, there are different gradated levels of, license types.
I like it. I like the idea. Yeah,
and,
I like
and
it.
the law doesn't envision it in most cases. I will say this, I'll undermine my own position here. In most cases, the legislature will tell us, okay, you could have this type of license type and this type of license type and this type of license type. And we don't necessarily create new license types, except in statute. However, having said that, the way this law is written, we do have pretty broad leeway to say, here's what the standards are for this license. And because it's really it's the same scope. If we're not changing the scope, we're creating a new license with a new scope. We're just saying this one is green and this one is blue. You can do the same thing with either one, but if you want the blue one, you can take these steps.
Well, the other thing it does, Jeff, is if I am a large company like Sunrun, and I hire companies to find leads for me. As a company, I can say, you got to have this kind of certification. You got to have the blue license.
Right.
In order for us to do business with you, which means that they're NABCEP certified, or they have this other they have the higher level of training or whatever. I like it. I think it's a great idea. Whether you use that company or not. I mean, I think
that's the thing with our process. I mean, a company like Recheck or whoever it is, they would have to come to us. They'd probably pay a small fee. We have to charge for these kind of reviews. They would have to get certified by us as a sort of a certification entity, right? And we would look at, okay, what do you do? How do you do it? What are your standards? And then we would approve them. They don't have to really necessarily get licensed or anything like that. It's just like an approval where we say, okay, you're an approved certifying entity, essentially.
Mhm.
And then,
Mhm.
you could go to any one that's an approved certifying entity. And so, yeah, that's how it works on our end. Again, it's not that unusual, but it's also it's not something that was envisioned in the statute. So it's kind of going beyond
I like it.
that. But, in the real world of what we do, that's kind of how it works. So, now, Stephen, tell me where I strayed there.
Oh no, you're fine.
Okay. So far, so good. But yeah, and that may be something where if something like that doesn't happen, or we haven't talked about this necessarily beyond this group. If there's not the appetite for that, with say executive leadership, or um, in the rules process, if it gets rejected, it could be a legislative initiative that somebody pursues
Yeah.
to say, hey, let's create a certified salesperson license.
Yeah.
Not unusual. Again, a lot of times when we get a new program, next couple sessions,
Has to be tweaked.
they fine tune it and sort of create kind of new pathways in response to industry input. So anyway, just a thought, something we can keep kicking around. If anybody else has any thoughts, if not, we can go on to compliance and standards. I know Josh is not here today. Him and Larry are doing some sort of training today. So, Stephen, did you have anything from the compliance group?
Yeah, just a few discussion points. So we met and we talked about the current draft rules and suggestions that had come in since the last meeting. And there wasn't anything earth shattering, but there were a few points that we talked about there that I'm going to want to get some feedback from the whole group on. The biggest points that came up during this meeting are having to do with whether the salesperson has to give a hard copy or a paper copy of the contract and the disclosure. And what we kind of settled on as a group is that they don't have to give a paper copy unless the person is over 65. Uh but if they do the contract electronically, they're gonna have to deliver the paper copy if they request it the next business day. It's not enough that they mail it to them; they're actually going to have to put it in their hand. There were some concerns about mailing of documents. There's been some recent change at the federal level to postmarks. Postmarks are no longer considered a presumptive date of mailing. And so that issue about what requires someone to mail something the next business day, that's raised some concern. There was a related concern about contract cancellations. The statute provides that during that 5-day right to cancel, the consumer can cancel. And there has to be either an email address or a mailing address for the consumer to cancel. It's not real clear on whether you go by if you're going to mail the cancellation, whether you'd go by the mailing date or the receipt date by the company. And so we had some discussion about either requiring companies to have an email address so that you can cancel the contract electronically, or putting that clarifying one way or another whether you just have to put it in the mail by that 5th business day, or whether it actually has to arrive at the company within the 5th business day. Understanding that previously postmarks were considered there's sort of a mailbox rule in many programs, and there's the idea that it was postmarked by the 5th day that you consider it a cancellation, and that really doesn't hold up anymore. So that's something we talked about. We would really need some discussion one way or another about whether we're just going to require companies you have to let them cancel by email, or if we're not going to do that, how we're going to compute when that notice of cancellation becomes effective, whether it's a receipt date at the company level or whether it's going to be the mailing date if it's going to be mailed. So we want to hash that out, those points out before we publish our proposed rules. So we're going to want to talk about that. We also had some discussion about continuing education. There really didn't so much come up in that group. I think it did a little bit, but we also had some discussion about that, me and Jeff, about the statute requires us to have rules on continuing education to renew your license. So it's not as urgent that we come up with continuing education rules for this rule package. But by the time this batch of registrants are going to want to renew their license, we're going to need a rule in place about what the continuing education is going to be. So we're thinking about addressing that in a subsequent rule package that will immediately follow this rule package. And we've done a little bit of research into what kinds of continuing education are available, what kind of courses we could require, and that type of thing. So that's another thing that's kind of around the corner.
I think we could use some help on that too, in terms of like what's out there. Keeping in mind that we're talking about salespeople, not technicians or laborers. I know for like if you're a worker, installer, there's plenty of stuff out there, but that's not really relevant to a salesperson necessarily. So if there's something out there that y'all know about, please
I can find
let us
out.
know.
I can find out. I have a question, Stephen. Was it discussed at all about non-English speaking customers? I mean, I know we're going to capture folks that are, above 65, but what about the folks that just really don't understand English?
That's a great point. The only thing we have about that in here is that the contract, it has to be written in English unless the consumer requests it in a different language. But we really don't have anything in there about requiring a paper copy if they're not English speaking. We could do that.
I think we should.
Okay. And I know Jeff and I had talked about, at least for the official disclosure form, coming up with a Spanish version.
Yeah.
That hasn't been done yet. But all right, we'll take that into account.
That's easy enough, especially with the disclosure form, because that's going to be something that we provide. Like we'll have a PDF on our website where you can download that form. We have all kinds of forms in English and Spanish, Vietnamese, whatever. So that's just something we could throw in there. That's not.
Okay.
Yeah. The other question I have, Stephen, do we have any solar companies on that committee? And because I'd kind of like to run it by some of the guys that I know are really ethical in terms of, how it could potentially work to make it easy for everybody. They might have some really good ideas about, printing, not printing, mailing, not mailing. I mean, how to make it easy for everybody.
Oh, yeah, Mark Bench was there. He was really.
Who was there?
Mark Bench. He was pretty vocal about the issue about he didn't want us to require paper contracts across the board.
So this is PriceSmart?
Yeah.
Yeah.
Okay. Okay. Good.
I forgot to mention that he also brought up about requiring a video disclosure. So apparently his company, when they do the solar sales, they actually put the consumer on video and they read some information to them to verify they understand the contract and they save it. And he was interested in making that a requirement. And I told him, well, we could talk about it in the group today. That's not something that's in the current draft. I don't know if that's something that we would require across the board, but he did make that suggestion. He says that he has a whole process that's sort of standard, at least as his company goes, and that kind of protects everybody because it protects them from claims down the road that someone didn't understand the contract.
Yeah.
But I understand there's some data storage issues if you're going to have to retain videos. We'd have to look at how long they have to retain them, and so forth. Well, those were the main discussion points that kind of came up during our compliance work group, and
I might run it by a couple of other companies just to see if we could get some more feedback from them on how they do it. What's working for them. What do they find is reasonable for both their company and the customer? And let me just run it by, and I'll get back to you guys.
Okay. So Jeff, do you want pause there, and then we'll go into the draft rules and later the agenda. Or do we want to actually have that discussion on those points like now?
On the points you just raised.
Yeah.
Yeah. Let's go ahead and talk about. Let's go ahead and talk about those now, and then we can.
Okay. So yeah, there's something interested in your feedback about. I can share on the screen kind of the draft of the rule and where we came about the paper versus electronic copies of the contract and disclosure, and then about the cancellation. I can share that up.
Sounds good.
Okay. Let me.
And while that's loading, John Medlock, did you guys has the enforcement subgroup met since the last meeting? Okay.
Yeah.
All right,
we have a draft if you want me to present it.
Okay.
Yeah,
we'll
do that, and then we'll go back to the rules draft after.
Okay.
Right.
Yeah, we do that, then we'll go to the whole rule draft, and we'll hit all those points. That sounds good.
Okay.
Go for it, John.
All right. Again, for those that remember, I am John Medlock, the Chief Prosecutor here at TDLR. Hopefully, about to come onto your screen will be the draft penalty matrix that we will be looking to implement for this program, knowing that it will not be finalized because, obviously we got to get rules in place. There'll be probably some other rules coming in place, but this is based on what we have now and kind of what the current draft rules are. This is kind of what we're looking at. As I told the work group on this, so what we try to do with these penalty matrices is we try to take all the laws and the rules and distill them into different categories or classes. As you can see on the screen, there's a Class A. We usually have about 4 classes, Class A, B, C, and D, with Class A being the least severe type of penalties and Class D being reserved for the more severe type penalties. We do a range of penalties and not just specific dollar amounts, and the reason for that is because you might have the same violation in 2 different circumstances, but the facts are a little bit different, but the violation is the same, so that sometimes warrants us being able to have a little bit of flexibility within that range. Also, what we try to do is, as you can see here, we have some different kind of subheadings. These are some registration notification type violations against a solar retailer and against a solar salesperson here. So we try to break it down a little bit. The reason we do that is for ease of use for the consumer, because this will be posted on our website. So anybody can that has access to the web can go and look and see what this will be in terms of, what these violations will be. Also, we do it because lawyers write rules for lawyers, not necessarily for the general public. So we try to distill these into what we call a plain talk version of the rules.
John, should we be seeing something on our screen?
Are y'all not seeing it?
Can anybody else see a document?
I see it.
I see it.
I can see it.
Okay.
Okay, it's just me then. Let's see if I can figure out where it is. Doesn't matter. Keep going. I'm sorry.
Okay. No worries. Thank you. I appreciate that. Yeah, but so we try to distill the violations down into more of a plain talk so that everybody can understand kind of what it is that we're talking about. But we also put the citation there on the right side in case you want to go look at the actual law and rules citation. So when we went over this with the work group, we talked about not only the different classifications and where these violations fell within the classifications, but also the penalty ranges within these classifications. We always typically ask, do these kind of hit the mark? Because you guys are the experts in the industry. Does this seem right? Does this seem fair? Those kinds of things. Ultimately, at the end of the day, my prosecutors will be bound by this document. And what I mean by that, if we're looking to charge, and just looking here at the Class A, if we're looking to charge one of these Class A type violations, that is the range in which we will go against. Now, we do have our Chapter 51, which is TDLR's enabling statute authority that gives us the ability to charge $5,000 per day per violation. But we don't always want to just be constrained by that. We want to use this because we want to make sure that when we're charging things or going against folks, that they have some sort of certainty or clarity about what it is that they could potentially be receiving in terms of penalties and sanctions. Because if we just did the $5,000 per day per violation, depending on who the prosecutor is and the day that they may be having, you might get different amounts for the same type of violation. So this way, it works for transparency and consistency across the program, no matter who might be the prosecutor in the case. Now, as you'll see, when we start kind of going in here a little bit, we have different, like I said, classifications and different categories of types of violations. And as we get up into the higher ranges, Class B, you'll start seeing that those violations start ticking up a little bit, and then you'll start seeing some sort of sanction on the actual license starting to be possibly being implemented. In these Class B, you'll see it's $1,000 to $3,500 range, and we put the and or up to a 1-year full suspension. And the reason we do that is because, again, sometimes we might need to add that additional license sanctions on top of the penalty. But at the same time, too, we don't want to necessarily just be everything that's a Class B get some sort of license sanction as well. And we say up to a year full suspension, which means that we can probably do any amount of time, 1 month, 2 months, all the way up to a year in suspending the license. But at the same time, too, we can also do a probation of that suspension. And what that means is if we suspend someone's license for a full year, but we probate it, we allow them to continue to operate under the watchful eye of us in case if they do get any kind of additional penalties or violations that come up, we can go ahead and impose that full sanction that we have against them. As we roll into our Class kind of C type violations, and I'm sorry I'm scrolling so fast, just kind of want to go through some of this real quick. We go to $2,000 to $5,000, which again is kind of that max range that we'll always go to, plus a 1-year probate suspension up to a revocation. So this is, like I said, these are our more serious. This is when we're really starting to impact, in the vast majority of our programs, like the consumer health and safety. This will be more of those financial kind of issues. Some kind of the lying, the malfeasance that might happen with some of these contracts that we've seen in the past that we're trying to rid and regulate here going forward. And then lastly, kind of our Class D, these are kind of the ultimate bad violations. They're $5,000 and or revocation. And or is because not everything that's here will apply to someone that is licensed. Sometimes they're unlicensed people, so we can't revoke anything if they don't have a license. But you'll also see some things in here that are Chapter 60 or Chapter 51. Chapter 60 are the administrative rules that apply to TDLR as a whole. Chapter 51, again, is our enabling statute. 71 will be the administrative rules for this program. So that's why you'll see kind of a kind of a myriad of swath of all those types of violations. Again, like I said, this is binding on my prosecutors. So typically what we do when we have advisory boards, when we make changes to this, we'll go through the work group, kind of get their feedback, get their approval, move some things. Then we'll go to the full advisory board, get their approval. Then ultimately we'll present this before our commission. So, and our commission will adopt this for our use. This penalty matrix, however, is not binding on our commission. They're just bound by our Chapter 51 authority, which is that $5,000 per day per violation. But they usually do take this into account when making their decisions. And the commission is the one who would only make the decisions in the cases if it ultimately went through the whole hearing process and it went to the State Office of Administrative Hearings and we got a ruling from them, a proposal for decision through them. Then ultimately we present that to the commission. They have that opportunity. They'll take this into mind, but again, their only real constraint is that Chapter 51 authority of the $5,000 per day per violation. So that's kind of what it is in a nutshell. Again, like I said, this will always be modified. This is a living document. So when we make changes to the rules, if there are new statutes that come into place, we will make updates to this. We will change that. Sometimes wording needs to be updated, changed. Different things happen. So this is not going to be a static document by any stretch of the imagination. It will definitely be a living, breathing, dynamic document as time goes on and it allows us to make changes. And when we do make those changes, we typically, like I said, we involve the advisory boards. being this program doesn't have an advisory board yet, we will definitely still get input from the industry when we want to make those changes to this, because we definitely want feedback from the industry to make sure that not only are you guys okay with this, but you guys want to make sure that folks in the industry are being held to a certain standard, and that if sometimes things are too low, they need to be bumped up to make sure that when somebody does do wrong, that we are appropriately going after them with the correct amount of penalties and sanctions. So with that, I'll ask if anybody has any questions, and I'll be happy to answer them.
Looks like
Hi,
a
good
great
morning.
start. Yeah, go ahead.
Oh, I was just going to ask, I think I'm on this work group, my apologies, but can you send this out to the entire group so we can read over everything in detail?
Absolutely. We'll make sure to get a copy of that to everyone.
Thank you.
We have a raised hand, Mr. Nance.
Hey, John, thanks for that overview. That was really helpful. I was wondering about like consumer redress or refunds for consumers, and maybe also cancellation of contracts, although cancellation of contracts, the statute seems to suggest that as an enforcement needs to happen after notice and hearing. But in setting up the penalty matrix, are refunds to consumers part of what y'all look at, or is that just a separate thing? That's one question. And then two is, do you have a way to like increase sanctions for repeat violations, or some sort of list of like aggravating or mitigating factors to help decide where you are within a range, including like possible aggravating factors for multiple violations? So those are my two questions, like consumer redress and like multiple violations slash aggravating factors that might warrant increase in sanctions.
Yep, absolutely. Yeah, not a problem. I can address all of that. So in terms of like consumer refunds, Chapter 51 in TDLR does give us refund authority in which we can impose refunds. It is limited to the amount that is the value of the service. Kind of a quick example is we regulate the fuel pumps in the state of Texas. So you go to a fuel pump, you get bad gas, you blow your brand new diesel engine. That new diesel engine is going to cost you $20,000. However, under 51, the value of the service was probably the $75. Now, what we do oftentimes, and this past year, TDLR as a whole got consumer refunds and restitutions in the amount of over $800,000 back to consumers. So it is a big part of what we do when we get cases, is we try to identify situations where there is a possibility of a refund or some sort of restitution that we can make to the consumer. This program is definitely going to be one of those ones that has that eye towards consumer refunds, because a lot of times the vast amounts that these contracts are talking about. So we can do it one of two ways. One, because these contracts are for a set amount, we can, through our enforcement actions, we can order that restitution or that refund and get the actual amounts that are paid back ordered to be paid back. So we can go through that route. We can also do it informally as well, where we don't have to necessarily do it through a direct order, but we can just get it done kind of in an informal manner. We've been very successful in doing that. In terms of things like aggravating and mitigating factors, that's actually why we went to that whole range in the different classifications, because like I said, you might have two violations that are the exact same violations in two separate cases. One may be a first-time violator, one may be a second-time violator. So one of the things that we do, we have a case management system that allows us to be able to not only track the current case, but it allows us to go back and see the history of anybody that's ever come in contact with the department. So we can search through the names, we can search through the companies to see if they've had any additional cases. We have what we call an enforcement plan, which kind of talks about how TDLR handles enforcement cases in general. But one of the things that is built into that enforcement plan, and thereby built into each one of these penalty matrix, is a set of criteria. Is one, we determine the severity or the seriousness of the violation, whether it was willful or intentional, whether they acted in good faith to mitigate or avoid some of these violations or corrected even after the fact. Again, if they're a repeat violator, if they've engaged in this in the past, then there's a certain level of penalty to deter, kind of a deterrence thing for the industry as a whole. Because if we're setting like every kind of unlicensed like contract at like $100, then what's the incentive to get licensed or to not do this, right? So we want to make sure we have that level of deterrence in terms of our penalties. And then the last one is always my favorite, is any other matter that justice may require, right? So that's kind of the catch-all. So yeah, we do have those factors built into the enforcement plan. But again, like I said, we were able to track everything. So one of the things we definitely do is make sure that if somebody commits a violation, it's their first one, right? We're going to try to treat them as fairly as we can. If they keep messing up, we're going to have to try to look at it through the evidence to determine, is this just something that they don't understand or know and they're continuously not getting, or is this just kind of a pattern or practice? And if it is kind of that latter one, and this is kind of more of the intentional, we're just going to see if we can get away with it kind of a thing, then obviously we have the ability to go a little bit higher if we need to.
And I would just throw out there on John's behalf, his folks have been really successful with kind of taking the carrot and the stick approach to say, you could be looking at $5,000 a day and revocation of your license, or you could pay this consumer back and make them whole. Your choice. Go ahead. And you know, the smart people 9 times out of 10 will take that take the restitution route. So,
all right.
is that a fair example, John?
That's a very fair example.
Yeah.
I have a question. I'm going to give you an example. There was a contractor who had been in business forever. He knew he was headed towards bankruptcy. He continued to collect $7,500 deposits, knowing he was going to declare bankruptcy. You know, went out and sold all these contracts and then disappeared. So if that's the case, would you go after him? I'm assuming everybody could get repaid their $7,500 and then you would go after him for penalty. Is that the way it would work?
So it kind of depends on when the bankruptcy kind of happens, because bankruptcy, one of the beautiful things about our system is bankruptcy does unfortunately sometimes trump some of the things that we can do. One thing that we can always do, regardless of a bankruptcy, of when it's being filed and what type of bankruptcy it is we can always go after the license itself. So we can always seek to revoke that license if necessary, suspend it if necessary. That is the one thing that transcends whatever's happening in the bankruptcy. Depending on when the violations occurred and when the person filed bankruptcy, we can potentially become one of those inline creditors to possibly be a part of the bankruptcy proceeding. So it just kind of depends. Unfortunately, there are some times when we become kind of more of that unsecured creditor, and we're probably just not going to get anything back. And kind of unfortunately, same thing for the consumer as well. So it just kind of depends on when the timing of that bankruptcy occurs.
Then I have another question. If I'm a homeowner and I've got some, contractor that comes out and just puts up what I call Christmas decorations, or excuse me, solar decorations on their home, and they've punched through the roof and they've just made a mess. Can they be made whole with their roof as well? Or is it just what they've paid to the contractor for the service? So say they paid $3,000 for the contract and it's going to end up costing them $40 to get everything fixed.
Right. So that's why I was kind of giving the example of the motor fuel, right? The value of the service is usually the tank of gas, $75, but the engine costs $20,000.
Right.
If we were to do our Chapter 51 authority of ordering it, the most we could order is the $75,000, or sorry, the $75. Now, that's what I'm saying is a lot of times we're very successful in being able to negotiate outside of what our authority is in terms of getting an agreed order or just kind of getting an informal resolution. So in a situation where, as you brought up, the solar decorations are put up there and they punch in holes and all that kind of good stuff, we will try to do our best to try to get that person to refund the total value of the damage. Knowing that if they choose not to, participate, we will try to do as much as we can in terms of maybe just the value of the contract. But unfortunately, like I said, if the person or the respondent wants to go through the full process and not kind of be helpful or in agreement, we will handle that administratively and try to get as much as we can. Unfortunately, there are limits to what we can do in that regard.
Got it. Thank you, John.
Mhm.
And I think that kind of loops into the insurance discussion, right? That we're going to have. Stephen, I think, will be talking about that soon, about what does the insurance cover? Does it cover actions by your, not just, I would think in most cases it would cover, damage to your roof. I would hope some kind of liability, but will it also cover, actions by the salespeople? So we can get into all that, but
Thank you.
yeah. John, real quick, where's things at with criminal conviction guidelines? Is that sort of later in the process?
Yeah, we're working on
Or is
that
that
one a
something
little
that's
bit
being worked
later
on?
because technically, since there's no real licensing yet,
Right.
we typically wait a little bit later till those kind of come online. So that'll
Okay.
probably happen more. We'll start developing that more spring as we're getting ready to come online with the licensing port of it,
Okay.
so that we can get that ready. So just to kind of preview for you folks here, we'll probably get that same work group back together because in addition to the penalty matrix, the other thing that we do in the enforcement division is we review criminal histories for all applicants, whether they be a brand new applicant or a renewal applicant. We review everyone's criminal history, and we have there are certain ones that we always look at for every program, but then there are certain ones that are more kind of program specific. Kind of just an example is if you have a bunch of DWI convictions and you want to be an air conditioning contractor, not that we're saying that we don't care about that, but it's not really directly related to the occupation. But if you're a tow truck driver, then we do care about that. So that's why I'm saying some crimes we care more about depending on the program and less about, not that we don't care, but we do. It's just that there's more emphasis. Just quickly off the top of my head, some DTPA type violations, fraudulent business practices, things like that would probably be kind of top of mind when it comes to this program for sure, because those are kind of the issues that we're dealing with and we want to make sure that we're preventing. But again, we'll get that group together. We'll create a draft kind of like what we did and kind of show it around just to kind of get everyone's feedback is what crimes do you guys think are important? Or, frankly, what have you guys seen as being part of this industry?
All right. Stephen, you want to pick up on the insurance discussion before we dive into the rule draft?
So this is kind of hard for a lot of reasons.
Yeah.
It's a new industry, and there are a lot of insurance products out there, and they cover all different things. We met with the Department of Insurance, and they gave us some information about different insurance products and some sample policies and so forth. And there were really 3 different categories we talked about. We talked about general liability insurance. We talked about professional liability insurance. We talked about CLRP or CLIP insurance. And general liability insurance is what seems to be the industry standard, and it's what's required in our program rules for a lot of our programs that someone would work in someone's house. That's what electrical contractors currently have to have as general liability insurance. And that's what's currently in our draft rule. General liability insurance covers accidents, it covers negligence, and this sort of thing. It would cover the employees of a company that is covered. The downside of general liability insurance is that it doesn't cover intentional wrongdoing, intentional acts. It usually doesn't cover breach of contract. So with insurance, it's relatively easy to get. It's relatively affordable. It's something that just about every legitimate company would have. So it's kind of a marker for having some authenticity as a company. It's something that we feel pretty comfortable requiring. The professional liability insurance, we talked about it a little bit. It's not real clear how it would apply in this context. Professional liability insurance is also referred to as E&O insurance, or errors and omissions insurance, and it covers errors in professional judgment. There are policies like that exist for various different professions, particularly doctors, lawyers, and so forth. It's something that we could require people to get in this industry, but they might have to get a tailored policy that covers this type of industry. So it's something that we really don't know that we would want to require off the bat. CLIP insurance, or contractual liability insurance policy, and CLRP, which is contractual liability reimbursement policy. Those are things we talked about that exist in our service contract program. And essentially, they operate as a form of financial security. So they guarantee to a third party that somebody's going to comply with their contractual obligations. And so that's something that we'd be interested in this industry, because if we were to require the solar retailers to have CLIP insurance, we could require that if the company breaches its contract to the consumer, that the consumer would be able to file a claim against toward the CLIP policy. So it's one of these things. It's a good idea in theory, but it doesn't exist in this industry yet. It's kind of a niche product that not every insurer offers. So it's very common for home warranties and extended warranty plans that fall in the SCP category. That's kind of a program that there's model legislation between many states, and so it's a niche product. There's a few insurers that offer it, and it would make sense eventually to head towards that. But I think for this rule draft, we kind of settled on just including general liability with $1 million per occurrence and $2 million in the aggregate. And that's sort of our rationale for doing that. We're knowing that insurance, it doesn't really provide financial security, but financial security is something that's not really in our statute. If we end up having a problem with the companies going bankrupt or becoming insolvent, we can look at legislative changes to require financial security, such as a bond or a letter of credit. Like I say, there is one form of insurance that takes that place. It does provide financial security, and that would be CLIP insurance. So that's really what our discussion was with TDI. And in our draft rule, there's a part in there that requires that the general liability policy covers the salespersons. And we had a little bit of follow-up discussion with TDI about what kind of documentation we would need, and whether a certificate of insurance is what we would need the companies to send in, or whether we would need them to send in the whole policy. And we're still having that discussion.
Stephen, I have a question, of course.
Sure.
Can you give me some idea what the policies that you're discussing, what they cost? Because I'm now thinking, okay, we're now going to have contractors that are going to barely be able to hang on based on what's happened with the tax issue, or the tax code stuff that just got changed.
Yeah.
And it's kind of a double-edged sword. I would like for as many companies as possible to remain in business, and yet I don't want them out there selling stuff and then going bankrupt, and then we don't have any way to protect the consumer. So I'm just trying to, do you have any idea how much a policy like that costs in general?
I don't. I think we heard from some people in our group that general liability insurance is relatively cheap because it doesn't cover very much. It's
Right.
It's limited in its coverage. It's covering basically if the salesperson were to trip, were to break your house, were to have an accident on the way to your house. It's covering.
It doesn't cover the consumer.
It's not covering the consumer very, very much, other than it's ensuring that the company has some type of coverage for liability. It's one of these things. It's questionable whether we want to require it. The CLIP policy is expensive. I don't know how much it is. I know that in the service contract industry, it's seen as a cheaper alternative to filing a letter of credit, what's called an irrevocable standby letter of credit, which is it's another way that you can require financial security. A letter of credit in this instance would be a financial institution is pledging that they will make the consumer whole, or they'll make TDR whole if we notify the financial institution that this company has failed to follow its duties under the act. So a letter of credit is relatively expensive, and in our service contract program, there's a requirement that you pose one of three forms of financial security, which could be a security deposit, like a cash security deposit, a letter of credit, or you can use reimbursement insurance. So reimbursement insurance is cheaper than that, but it's still a significant cost, and it's something that we'd have to kind of look into. I think as the industry matures, it's something we might look into. But I don't know. I don't know how much it costs.
All right, thank you. I might ask around.
Yeah.
Yeah, I think, Stephen, from some of the research that was done, it's generally accepted industry standard to have the general liability already. So anytime we're introducing rules, administrative rules, we have to be wary of and conscious of, is this going to have an adverse impact on existing businesses? We can't have something where it's just like, oh, okay, you're going from $100 a month to 5,000. That's gonna get shot down. So you kind of start out at what's the least disruptive pathway, and then go from there. So
That's you.
Stephen, do you want to go ahead, jump into the rule draft?
Yeah, sure. So let me just say, we've started the process of getting a fiscal impact analysis. Now, we are still making some changes to the rules. So what will happen is, after today, once we have a better idea of exactly what tweaks we're going to make to this rule package, I'll update our financial analyst with that. And then he's in the process of putting together a fiscal impact. That is a required process under the government code for rulemaking. Basically, as an agency, we have to analyze and determine if the rule is going to have a fiscal impact on small business, micro business, whether it's going to impose a cost on other state agencies, and so forth. There's a number of steps we have to go through, and if there is a cost, we have to kind of analyze what it is and talk about the public benefits of it. And those are things that the governor's office will look into. As part of the process, we'll send them our fiscal analysis. And we also will, as part of the public comment process, we'll invite the public to provide information about fiscal impact. So fiscal impact is going on in the background. I'm going to share up the latest version of the rules, and I'll kind of highlight the recent changes that are being talked about. And let me go ahead and share that up right now. Okay, I am sharing the version of the rules. Let me know if you can see them. I'm just going to kind of highlight the parts that have changed since our last meeting. They're the parts that we're still talking about changing. So, as you know, I think we mentioned at the last meeting, we decided to change the definition of lease to include a power purchase agreement. And that was based on some discussions with the industry, but also on a legal analysis that the definition of a lease under applicable law, including Article 2A of the Uniform Commercial Code, which deals with leases of goods, it's broad and it includes any kind of agreement in which you're given the use of an item in exchange for consideration. So we're going to argue as an agency, we're going to propose that a power purchase agreement effectively is a type of lease, and that we have the authority under the Act to regulate power purchase as leases. And we built that into our definition of a lease. We also included the definition of a power purchase agreement in the definition. Mary Hoffman, who's our expert on licensing, she suggested a number of changes to the registration subchapter in the rules. And these are things that are pretty common to every program. It's really kind of rearranging things. It's not real substantive changes here. She's including about obtaining a license or registration by false representation is ground for denial. You can't let somebody else use your license, and those are things that are also in the chapter 60 rules, but it's just sort of reorganizing them. A couple of key points that she wanted to emphasize on these rules were that if there's a change in ownership, then the license isn't transferable. You have to apply to a new license. That'll be on the retailers. We get into that a lot sometimes with different programs about there'll be a change in ownership and they don't want to apply for a new license. So that will be in. We're planning to include that in the rules.
And let me just point out too, that's true for all our programs. Any type
Yes.
of company license or business license, if you change owners, you don't get to transfer that license to somebody else. They got to start over a whole new process. So that's just keeping in line with our existing processes.
Yeah.
And I also wanted to jump in.
Sure.
We didn't include the change of controlling persons, but also that needed to be added. If there's any change, we have a comment there. We just haven't, I don't think, added it into
I
the
haven't
rule
added that
draft.
before.
Yeah, so if there's any change in controlling persons for the company, we'll need to be notified as well.
I put it right here.
Yes, it can go as the new E and move everything. Oh, okay, that works too.
I'll pencil that in, so I'll make sure I don't forget that.
Well, the change of controlling persons doesn't necessarily mean that a new application has to be submitted, because a controlling person by definition doesn't mean it's an owner of the business.
Okay.
It can be someone who's just operating or running the business. So that those need to be two separate
Okay.
items.
Do we want our 7121 registration requirements for retailers? I think we have it there about
Each controlling person, oh yeah, is subject to the criminal history criteria. Yeah.
okay.
You can put it under the retailer section if you want, because it's only applicable to retailers. It doesn't obviously apply to salespeople. So
Right.
Well, I'll be sure to add that in.
okay.
Oh, I'll make a note of it. Okay, that's a good point. Mary has some very good points. She's also the one who brought up about including the email address for cancellation. We'll get to that in just a moment. So we had talked about insurance, and I'll skip over that. Other than we're having that discussion about what exactly kind of documentations you're going to have to submit on your licensing application. Submit with your licensing application. 7140 and 41 is dealing with the requirements of the contracts, and this is where we had some discussion about should you provide it? Do they have to provide a paper copy or by email? We had kind of gone back and forth on this, and at least within our work group, what we came up with is the general rule is you have to provide the consumer with a printed copy of the contract. But if the contract is completed electronically, so if you're completing the contract on the iPad, then the consumer can opt into receiving it electronically. But we have some cautions in here about before the consumer can elect into saying they just want an electronic copy, a salesperson has to verify that the consumer has access to the internet and is able to view electronic documents. If the consumer says, well, I also want a hard copy, then we made this change that they have to actually deliver the printed copy the next business day. That was because there was a concern that if we just require the sale retailer to mail the printed copy, it might not get there within the 5 days that they would have to cancel or need into their cancellation time. So it's sort of the carrot on the stick, so to speak, that the salesperson can do this thing just electronically, but the consumer still has this option to have a paper contract and won't be disadvantaged by completing the contract electronically. Was kind of the intent there. We also had a little bit of talk about the Federal E-Sign Act, and we have it here that they have to have a consent to electronics signature, and they have to keep. That's one of the documents the retailer has to retain in their record. So if there's ever a question about it from TDLR about, hey, did they consent to sign this electronically? There has to be documented electronic consent. 7141 is related, and that's having to do with the agency's disclosure form that has to accompany the contract. We had talked about whether that can be electronic or whether that has to be a hard copy. And sort of what we came up with in our subgroup was that it follows the contract. So if the contract itself is electronic, that disclosure sheet can be electronic. If the contract is printed, that has to be printed. But the exception was that if the consumer is over the age of 65, at least that disclosure form has to be printed and put into their hand. And today we talked about, or they don't speak English. I have no problem with adding that in. I don't.
Well, I think that they need to be given. It needs to be given to them in their first language.
Okay.
They have to be able to understand it.
Yeah.
Because a lot of times you think they act like they understand it, but they don't necessarily understand it. And so I just think it needs to be given. Everybody's protected if it's given to them in their first language. It just means that the contractor's going to have to carry different kinds of, documents with them, and that's too bad.
Well, one approach might be and I've seen this in the finance code in a couple places, but like if the transaction is conducted in a language other than English, then this is just the idea. I don't know if this is the exact language, but like the general idea would be if the transaction's conducted in a language other than English, the consumer should get accurate disclosures in the language in which the transaction was conducted. That way you don't need to get into like what your native language is or those kinds of issues. And that doesn't necessarily require that might be a separate issue from whether TDLR has a Spanish form or not, right? And that's not really specific to Spanish. That's consistent with other languages. So that it doesn't really get to adopting a Spanish form or what the requirements for Spanish would be, other than it needs to be accurate. You should probably put something in there about accuracy. But yeah, that's what.
Well, I can tell you there's a real problem in the Valley. And we've got a lot of people down there that are getting tooled over. And so they need to be able to say, the Spanish speaking people, if they need to protect themselves, they need to have something that they can refer to. So that was my only reason I brought it up.
Yeah, there's kind of a flip side, which is whether the English copy is kind of the controlling copy for purposes of evaluating whether, like when TDLR is looking at whether someone complied with the rules, is the English version of the contract and the disclosure controlling or not? Or do you just want to stay silent on that? But if you kind of have a decision to make of if you're silent on it, that might come up in complaints.
Well, I just want to say on the PUC side for retail electric provider contracts, the way it's handled is the language has to basically be consistent through the transaction.
Yeah.
And the language preference is documented somewhere. So documented by the retail electric provider. So it doesn't. Some places it mentions specifically Spanish, but in a lot of places it just says, whatever the other language is, be consistent throughout the transaction and document that language somewhere.
So maybe they have to sign a contract, not only the disclosure, but the contract itself needs to be in their native language. Is that a problem? Is that what you're saying, Mike? You're muted. Mike, you're muted.
Sorry, yeah, it's if the promotional materials and the contract are in a different language, that needs to be documented. I don't, speaking to what Matthew was just saying, I off the top of my head don't know about the controlling language and how I'd have to look into that. That's a very good point. I don't know off the top of my head. Somebody here does.
Well, yeah, if you're doing a transaction in like Vietnamese and the contract is in Vietnamese and the person complains to TDLR that they were overcharged, can TDLR process that? That's kind of a question for considering in that.
That's a great question. Jeff, are we going to make this available in English, Spanish, and Vietnamese, Chinese?
I'd say at this point,
I need Spanish.
Spanish for sure. It depends on what translation we have available. Depends on if we have staff available. I think we have Vietnamese translation services available.
All right.
So yeah, it is pretty common for us to do English, Spanish, and Vietnamese because those are kind of the three biggies in Texas. So, yeah, for the disclosure form, I don't see why we couldn't do all three. It'd be pretty standard. So.
Yeah, I know there's about language minorities in the Voting Rights Act. They went by, just 5% of the public speak that language in the affected area. And there's something about that. I know for sure we need Spanish.
Yep.
I'm on the fence about whether we should put in our rule that the department will make the required disclosure form available in English and Spanish, or if we just leave that blank but understand the way I just added this in that the salesperson has to present it in the consumer's preferred language if the department has made a form available in that language.
We're talking just about the disclosure form here.
Yeah,
right?
disclosure form, not
Yeah.
the content.
Yeah, I think that gives us some leeway because if we decide in the future we want to add another language, then we're not bound by just those three.
All right. So, any other thoughts on that piece about the disclosure form? We have from the work group that it's automatic that you have to give a printed form if they're over 65 at the time of the transaction. And I'm adding in there, or if the consumer indicates that they are not fluent in English language. I don't know if we want to rework that and make it the salesperson's duty to assess if they're fluent in English. We could rework that a couple different ways. But basically, the idea is that if they're limited English proficiency or if they're over 65, you got to actually put a printed form in their hand.
I think that's good for now.
Okay.
It may not be perfect yet, but I think it's going in the right direction.
I can't see the document you're looking at. Does that do they have to do it within a certain period of time? Because it's like if they don't give it to them till after the 5 days.
Well, they have to give it to for those classes. They have to get it at the time of the transaction.
Thank you.
Yep.
So that's a change. But that's how we printed that. The right to cancel.
So sorry for interrupting. From my understanding and from reading it, it is not at the time of the transaction, it is before the transaction, right? Because it is giving an overview of what is included in the contract. So I just
that's right. That was a change we made. I misspoke. At one point we had written it that it's at the time, but I believe in the latest version that you have to give it that prior to them signing that contract.
Prior to signing, yeah.
Before the consumer signs.
Yes.
Right, but it is considered part of the contract. For purposes of the way you describe the contract in that disclosure form, it can't contradict what's in the contract itself. But yeah, it's the first thing you would have to sign before you sign the actual contract. Is giving you. We're still working on what's on that form, but it's basically going to summarize the key terms of the contract and how to cancel the contract. Okay. Well, I feel pretty comfortable with that part. We need to settle this cancellation business about how if they can automatically do that by email, or if it's going to be by mail, what date we go by. Is it going to be the date the consumer mails the cancellation form, or is it going to have to be the date the company receives the cancellation form? By way of background, this stems from the statute 1806-156. And the statute says it either has to provide a mailing address or an email address. So I don't know that we could say that it has to be an email address. I think the company gets to pick if it's mail or email address, but if it's going to be a mailing address, we might want to work in here how the time is computed in terms of mailing or receipt. I think it's sort of defaulting to receipt. But this draft talks about must provide the written notice before the 5th day, and that's kind of ambiguous in that regard.
So, just another thought, representing older adults who prefer to call somebody rather than communicating via email. Would somebody be able to cancel a contract over the phone, or would it require some type of hard copy, like something in the mail or an email address where there's actually some type of record?
Looking at the statute now, I was trying to put that in our chat here. While I'm here, I have the chat up. I see someone. Okay. So the way the statute is written, it says, in a B here, notwithstanding any other law, so a retailer shall allow a buyer or lessee who enters into an agreement to purchase or lease a solar system to cancel without further obligation by providing written notice of the cancellation on or before the 5th business day. So the statute is talking about the consumer providing the notice before the 5th business day. Not necessarily talking about them having received the notice by the 5th business day. And in C here, it says that some retailer shall include in the agreement the last calendar date on which the cancellation period, so the last day you can cancel, and the mailing address or email address for providing the notice of cancellation. And D is saying that if you don't specify, if they don't provide that notice, that you can cancel by any reasonable method. So, Matthew, so you got your hand up. Can you chime in?
Sure. Yeah. Just a couple thoughts on this. One, it appears the notice needs to be written, and the legislature is contemplating that it's either the legislature is listing mailing address or email address, which kind of suggests to me it needs to be written. But I do think the legislature seems to be contemplating that the consumer should get a full 5 business days to think about their decision and decide whether they want to cancel. So this stuff gets a little tricky, but I think we should consider it in light of the legislature wants the consumers to have a full, or at least approximately a full, like 5 business days or a week, right? When you take out, they define business day as, I forget if they exclude Saturdays. Oh, they do. Yeah, they exclude Saturdays, Sundays, and legal holidays. Okay. So they want the consumer to get a full week plus holidays to think about their decision. I have not studied all of these requirements, but there's a couple I'm aware of. And one that I was looking at was Regulation Z. So for mortgages that aren't home purchase mortgages, Regulation Z, which implements the Truth in Lending Act, has a right of rescission of 3 business days, and that the consumer can put their cancellation in the mail on the 3rd day. So that there is some precedent for letting the consumer put the thing in the mail on the last day, and then the creditor, the company, presumably has to allow some additional period for mailing if that's how they want to get their notice. So I don't know, maybe there could be something in here about, the consumer would need to either deliver it or send their email or place the cancellation in the mail by the 5th business day. If you want to follow that kind of Reg Z approach, that could also be an incentive for companies to use email rather than mailing, because if you're going to allow mailing, you would have to allow some additional period of like 3 business days to wait for the consumer's cancellation to come in. So if we want to like create an incentive for companies to keep it simple and use email, that it would mean they don't have to wait as long. But anyway, those are just some thoughts on that as a possible framework. But yeah, you get into these words provide and deliver. That was one thing I mentioned in our subgroups, is that the term provide is a little bit looser and can include things like enabling access to, or that kind of thing. Deliver is a bit firmer and it suggests actual receipt. I think both of those terms might have their places, but those are important terms to keep in mind.
Stephanie, I have a question.
Sure.
Do most folks over 65 have access, or do they have computers? Do they have access to computers? I mean, is it
I think it really varies, but especially like in the rural communities, I know there are challenges with access to internet at, reliable internet and at certain speeds. So just putting that out
might
there.
be true in the valley too. So if we have either or, right?
Yeah.
The question I have is, does it need to be some kind of formal document that they need to mail in, or can it just be on a piece of paper? I want to cancel. I mean, how do we handle that piece? Because it might be easier if for someone over 65 to mail it, as long as they've got something they can mail.
If you don't mind if I jump in here, this is Mary with TDLR, licensing manager. In our registration work group, we had discussed TDLR creating a cancellation form to be used possibly. And so that is an idea that we can draft a cancellation form that is available on our website for consumers to use for cancellation purposes. I wonder if we go into the idea of whether the cancellation form is required for consumers to use our form, or if they can cancel in other forms as well. But that was just a discussion.
What if we make it a requirement that the installer has to give them that form?
Provide the form?
Yeah.
To the consumer at the time of the transaction, so that they have a paper form if they do not have access to the internet.
Correct.
I would like for it to be provided maybe at the time of the signing of the disclosure, since the disclosure should be required around the same time. It should provide information about the 5-day cancellation policy. But I mean, ideally, I hope that any type of communication would be accepted as a notification of cancellation.
Oh, Mary, you get your hand up. Thoughts?
Yeah, again, TDLR can draft the form and have it available. And if that is something we wanted to put in the rule, that the paper form or an email version is submitted to the consumer when the disclosures are provided, I'm okay with that. However, I think we need to make clear whether using that form, the cancellation form, is required, or if they have another avenue or method of cancellation, if that would be acceptable. So
why don't we put that the department may establish a form for cancellation, and that if the department does establish a form, a retailer must accept that form. I don't think the statute requires us to establish a cancellation form.
no, it's just a courtesy.
Yeah.
Mm-hmm.
Well, I just want to make it easy.
Right. Make it easy. Have a document to provide information that may be required for cancellation. Just making sure that we have the information needed to do the cancellation properly.
As far as date of mailing, I got into this a whole lot when I worked at Texas Workforce Commission, and we're doing unemployment cases. You get into someone filed a protest to an unemployment claim on time, when they filed their appeal on time. And they have some pretty robust rules about presumptions of date of mailing. And I'm tapping into that a little bit, where you have the internal document date, the date that the consumer writes that they are sending the letter. Right? They have the postal meter date, if it's metered mail, postmark date, and you have the date that business stamps that they received the letter. So I think we could work it in something like this. I'm not real sure how to do this. In those rules, in that system, the postmark was presumed to be the mailing date. And if the letter wasn't postmarked, then it would be the internal document date if that date wasn't more than 3 days before the date of receipt. I don't know that we need to get into all that. I'm thinking about just putting that, look, if you won't accept cancellation by email, then you're going to be stuck with it's going to be presumed to be the date that the consumer wrote on the cancellation. And that way, that's giving the retailer an incentive to accept cancellation by email. I don't know if we want to go into these presumptions about postmark and receipt date, or adopt this 3 business day rule from the date of receipt. The problems with that is just variability in mail delivery, and there's changes at the federal level of the date that the Postal Service postmarks mail. They recently decided that they won't postmark it the day that you submit the mail. They're going to postmark it when they begin processing the mail, which could be several days later. So I don't know that we should rely on that. I could see that becoming an issue. This one will complain that they did cancel their contract. The retailer says no, they didn't do it on time. I think we need some kind of a way to resolve that. It'll be easiest if the consumer keeps a receipt, from the post office or from the postal kiosk that shows the day that it was accepted. But without that, just mailing it first class mail, I think there's some ambiguity there, and we should probably resolve that in favor of the consumer, unless the retailer is allowing electronic. I know this has been a big issue with, there's also a 3-day right to cancel under the FTC rules for door-to-door sales, and also under 601 Business and Commerce Code. And that applies to all sorts of things that are sold door to door, like magazine subscriptions and things like that. But a lot of times there's a problem canceling. It'll say you call this number to cancel, and then you call that number, you get put on hold, you can't get through, they're not really going to pick up the phone. And when we wrote this statute, we wanted to make it easier to cancel. We wanted to kind of get rid of some of that guesswork if we could. And
well, I can tell you in terms of this installer, what they typically do is once they make a sale, however the sale is made, they begin by going ahead and ordering the equipment and starting the permitting process and all that stuff, which costs them money if the consumer cancels. If we just say, okay, guys, don't order your stuff till X date, then I can't see that they're going to flip out. It's just unless they're trying to order in bulk or whatever, but that's their problem at that point. I think we do it by postmark.
Okay.
I mean, I just think that's the easiest.
Yeah, I mean, I guess the problem is, and that's the retailer's problem. If they're only going to accept it by mail, they're not going to accept it by email. Then,
well, I mean,
the
I think
problem
they
is
can
the mail
accept it by
delivery might
both.
take more. The mail delivery might take more than 5 days, but it shouldn't. You wait until the 5th day to mail it, and you went by the postmark. Just understand there might be a few more days there that it could come in the mail.
Well, they could always check back with the customer.
Yeah.
Did you mail it or not? We'd like to move forward. I mean, as far as I'm concerned, it's on them.
Yeah, it's a good point. I think we'll make it simple.
I had 2 suggestions. One was this first phrase, if the solar contract does not provide for cancellation by email. I think you want that to be if the solar contract provides for cancellation by mail, because if it provided for both, then mailed cancellation would be effective when placed in the mail. So I kind of flagged that. Like what if they provide for both? If they provide for both, this is leaving it kind of unclear what happens to the mailed cancellation. Okay. The other, related to that, I think we're talking about mailed notice of cancellation. It's like if you mail it, then it's effective on the date of mailing. So I would add the word mailed before notice. Mailed notice of and then the end of that sentence is mailed. I would suggest is placed in the mail, because I feel like people are gonna understand what that means. If you just say is mailed, then I think we're getting into this kind of mess of what does that mean? Does that mean postmarked? Does that mean it's processed? I think people have a better idea of what placed in the mail. And let's I put it in my mailbox. I put it in a mailbox. I surrender it to the custody of someone who's going to take it to the postal service. And that's a term I've seen used elsewhere. I feel like people know what that means. Yeah, and then you can get into rebuttable presumptions, and if you want to work if you're gonna incorporate postmark, I feel like postmark might be worked into rebuttable presumption somewhere, but I'm not sure that should be the actual date. I think the controlling date is the date someone puts it in the mail, but
Okay.
that's just my suggestion.
All right, we'll work on that. Other than that, there weren't a lot of other changes to the rules. Let's see. There was the issue about what actions a retailer has to take in response to if they discover a violation, and we made some relatively minor changes to that.
I think I was the one that submitted that. I think
Yeah.
it just seemed like what was written was that it was mostly around the salesperson or the retail business communicating to the customer, but it didn't seem like there was much action that action was required. So I just wanted to kind of clarify the language to ensure that action was going to be taken to remedy the issue.
I saw that and I didn't quite understand what action that would be, so I didn't include that for now. But if you have more clarity about what what we want to make that, I'm certainly open to that. I think we put it the way it's written right now. They have to provide the correct information, and they have to reprimand the salesperson. You had also suggested putting in there that they have to take some kind of action to make things right, and I just wasn't real sure how to phrase that, or what that would be, or if that's really something that would be.
Well, I guess I just didn't want it to be that the only way that the employer could handle it is by some type of what did you say, was like a penalty or something to the employee? Because if it's necessary, then they should be able to fire the person. But it sounded like that wasn't an option.
Yeah. So the way we have it now in this version is this is in 71.50 B4. It's saying that the sole retailer must exercise reasonable supervision over the salespersons, including the obligation to, and 4 says, take the following steps where applicable in response to violation of the act or rules which becomes known to the sole retailer. We have providing accurate information to remedy false or misleading information, and taking corrective action, including at a minimum a written warning. So it doesn't mean you couldn't fire them. It means you have to document the corrective action, and then provide remedial training reasonably necessary to prevent recurrence. That's the way we currently have it worded. The way you had suggested, there were 3 parts. There was basically that, and also taking action to remedy or to make the consumer whole. And I was just a little bit unsure about that.
Because for A, it sounds like they're required to provide the customer with information, but it doesn't mean that they're actually going to take action to remedy a situation. So let's say it's the equipment isn't fully working, then it just sounds like it's just telling the business would be providing information to the customer, but they wouldn't actually be taking the appropriate action to remedy the issue.
I see. I like where you're going with that. I'm not sure from an enforcement perspective if we were to put that they have to take adequate steps to remedy or to make the consumer whole, if that is something that would be enforceable, or if that's something that needs more specificity about what that is. And so I didn't take it out because it was a bad idea. I took it out because I wasn't real sure if that's the best way to phrase that, or if maybe we need more specific. Are we talking about letting them cancel the contract? Are you talking about providing remedies under the contract?
Y'all are the expert around the language, so I don't want to. I completely understand not using my language. I just think we need. Yeah, I would like for us to try and clarify.
Okay. John Medlock, do you have any comments on that? You know what we're talking about? I know that'd be hard for you to follow along because we don't really have that.
Steve, I think John had to jump to another meeting.
We had to jump. Okay. Well, we'll get with enforcement
we'll
about
follow
that.
up with him.
Yeah, we'll follow up with them. All right. So those were the main changes that we've made to these rules. Everything else is pretty much straightforward. Some typographical changes here about calling it a registration instead of a license. I don't really see anything else. I feel comfortable enough that we could publish this as is, or make a few tweaks to this and then publish it. But I understand we're going to have a second wave of rulemaking to address continuing education requirements once we kind of settle on what those should be. We did look into that a little bit yesterday. There's some community colleges that offer courses on being a solar salesperson. I think Northeast Houston College. There's a couple down in Houston that have that, but uh, they're really more aimed towards installers and figuring out what kind of a solar energy system you should offer someone, what kind of specifications it should have. There are a few courses out there, but I don't know. I think for barbering and cosmetology, for example, it's 4 hours of continuing education each year to renew your license. I think it's something like that. About 4 hours of continuing ed, and we just have to kind of our department licenses continuing education providers, so that also require a change to our Chapter 59 rules, and we just have to work out some bugs about that, about how someone would become how a continuing education provider that's licensed by TDLR would be qualified to offer these solar classes, and what would be the content of those solar classes. So that's something we still need to develop. Jeff.
Yeah, and I like the idea of having that as a kind of separate piece, because we do have quite a bit more time on that, and we should take advantage of that time. Since,
I can also find out what's out there, guys.
Yeah. Yeah, we need to do some more research on what's out there, how many hours. We don't want to make a requirement for something that is going to be difficult for somebody to even fulfill.
Fine.
So, yeah. But Stephen, I was just going to make a suggestion on the draft itself.
Okay.
If we could go ahead and make some of the changes talked about today, any kind of final tweaks, then distribute that draft to everybody, and give everyone a deadline of January 31st, 10 days from now, for any kind of final, quote unquote, final comment. This is not your final chance, but final for this version input, and then we can move ahead after the 31st with governor's office filing, all that, the next steps, public comment, all that, and of course there will be several more bites at the apple between now and then. So but just for this draft, let's try to put a bow on it for the 31st.
Yeah.
Does that work with your timeline?
I think so. I'm still waiting on the fiscal impact statement. So
okay,
that sounds about right. That's about what we'll. I'll make the changes here.
Yeah.
We'll ask for final kind of internal comments, and then I'll send this to our financial analyst who's doing the fiscal impact, and then we'll go from there. Well, we have to get the government. We'll have to get internal approvals from exec, and then get it to the governor's office, and then publish, and then it looks like we're aiming for that May commission meeting.
May commission meeting again. So that seems a long way away, but with everything we still have to do in terms of approval and publishing, it's going to come up pretty quick. So I think we're on a good timeline at the moment. So
we'll continue to have our subgroups meet to talk about things. We're still working on the consumer form. We're working
forms,
on education,
enforcement, penalty matrix, criminal conviction guidelines. There's still a lot of subgroup stuff to do. So in the background while that's going on. So great.
All right, sounds good.
Well, and this so item D on here was additional subgroup assignments. I think maybe I'll just kind of talk about the timeline. I think it'd be a good idea, or Stephen, let me know if you agree, for this group, the big group, to meet again on the 25th, February 25th, to give time for some of this to sort of cycle through.
Okay.
And then the groups that do need, I think all the groups probably will need, the subgroups will need to meet consumer registration, compliance, and enforcement. So that'll give everybody time in between to circle back with their subgroups. We'll put out invitations to those with agendas on what we need to accomplish. And keep our fingers crossed that we don't get derailed. So
You
somewhere
guys are
along the way.
great.
Yeah, these things can,
Yeah.
you know, once they get out into the real world, you know, anything can happen. So we'll see how it goes. But if this group is happy, then I feel pretty good about it. So,
Yeah, is what it is. It's part of that process.
or at least,
never know what
or at
the
least,
going to do. Never know
at
what
least,
comments are going to come in.
yeah.
Never know what governors do. But it's all part of our process.
Happiness might be too ambitious. Maybe just not unhappy. Let's put it that
Yeah.
way.
Can't make everyone happy. Yeah. Make somebody feel happy. That's also dangerous.
Yeah.
There's something wrong for making everyone happy.
Right. Probably not doing our jobs, making everyone happy. Yeah. All right. Well, 25th, I think, is a Wednesday. Do I have that right? Yeah. So yeah, that's
25th is
yeah.
a Wednesday. However, that date might not be available, so I'll talk with you about some alternative dates.
Oh, okay. Do we have I think you're right. We do have well, I don't see anything yet, but you know more than I do about the calendar. So
Yeah.
I know the week before that we have a holiday. So I was kind of down on that, but we could do the week before, the 18th, maybe, if that's available. I like keeping it to a Wednesday just for everybody's consistency, but
Yeah, week before we have a board meeting
on the 18th.
on the 18th. Yeah.
Okay. Yeah, we'll talk about days
But yeah.
that work. Yeah. And
We'll
let
get
everybody know.
that sorted out and then sent out
Yeah.
right away.
I don't want to convene this group too soon after I want to have the subgroups plenty of time to meet, and then our review process plenty of time to play out before we convene again with the big group. So sometime towards the end of February, we'll nail that down.
Bye, everybody. Thank you,
bye.
everybody, for hard
Yeah.
work.
Thank you so much.
I think we're good. Yeah. Thanks, Pete. Appreciate all the feedback.
Okay.
Talk to everybody soon.